You're standing at the bank counter. Your mother is 76 years old and she is gripping your hand like she is holding on for dear life. The branch manager slides a signature card across the marble desk. Your mother's hands are shaking, not from fear, but from early-stage Parkinson's. She cannot write checks anymore. She cannot manage the online banking. She keeps forgetting to pay the electric bill, and last month her phone got shut off because a payment never went through. The banker smiles. He has done this 1,000 times. He says, "Mrs. Patterson, the easiest thing is to just add your daughter Emily here as a joint account holder. Full access. She can pay your bills, manage everything. And if anything ever happens to you, the account passes directly to her. No probate, no hassle, no lawyers. It is clean. Your mother looks at you. You are her oldest. You are the responsible one. You took care of Dad before he passed. You have power of attorney. You are the executor of her will. She trusts you completely." She nods. You both sign. The account that holds $340,000, her entire life savings, the money she wants split equally between you and your two brothers, is now a joint account with rights of survivorship. The banker hands you a debit card. You walk your mother to the car. You feel relief. You feel like you just made her life easier. You feel like you are being a good daughter. And I am here to tell you, with the full weight of 18 years of elder law and estate planning experience behind me, that what you actually did at that bank counter was trigger a legal mechanism that will disinherit your two brothers, blow up your mother's estate plan, potentially disqualify her from Medicaid if she ever needs nursing home care, and expose her entire life savings to your creditors, your spouse's creditors, and a tax bill that could have been completely avoided. You did not simplify your mother's finances. You created a ticking inheritance bomb that is going to detonate the moment she dies. And here is the part that should make you sick. The bank knew this. The branch manager has seen this disaster play out 100 times. But he is not a fiduciary. He is not your attorney. He is a banker whose job is to make accounts easy to open, not to protect your family's legacy. And there is a legal structure, a specific type of account authorized under state banking codes in all 50 states that would have given you the exact same access to pay your mother's bills without any of the catastrophic inheritance consequences. But nobody told you about it because the default option is faster, easier, and generates zero liability for the bank. I am going to spend every second of this video exposing the exact mechanics of the joint account inheritance trap. I am going to walk you through the brutal legal reality of what happens when a senior adds a child to their bank account as a joint owner versus as an authorized signer or agent under durable power of attorney. I am going to show you how rights of survivorship override your will, your trust, and every intention you ever had for your estate. And I am going to hand you the legal blueprint, the actual alternative structures that elder law attorneys use to protect their own families, to dismantle this trap before it destroys your inheritance. If that sounds like information worth protecting, hit the like button right now. I am serious. This is not me begging for validation. The YouTube algorithm in 2026 actively suppresses financial education content that teaches families how to avoid probate and protect inheritances because it competes with paid financial services ads that generate billions in platform revenue. Every like you give this video tells the algorithm, "This matters. Push this to more families." Every like gets this past the suppression filter and into the feed of one more adult child who is about to walk into a bank and make a $340,000 mistake. Hit it right now before you scroll past this moment. And if this is your first time on the Jordan Retires channel, subscribe and turn on notifications. We do not do surface-level retirement fluff here. We do not do feel-good listicles about the 7 things boomers wish they knew. We do inheritance autopsies. We do estate forensics. We crack open the exact state statutes and banking regulations that are systematically transferring wealth away from the families who earned it and into the hands of unintended beneficiaries, creditors, and government agencies. Subscribe and get every upload. Now let me tell you about Emily and Margaret Patterson. Margaret Patterson is a 76-year-old widow living in Naperville, Illinois. Her husband died in 2019. She has 3 children. Emily, age 52, Michael, age 49, and David, age 46. Margaret's estate plan is simple. She has a will drafted in 2018 that splits everything equally 3 ways. 1/3 to Emily, 1/3 to Michael, 1/3 to David. Margaret has $340,000 in her checking and savings accounts at a regional bank. She has a paid-off home worth $420,000. She has a small IRA worth $95,000. Total estate value, approximately $855,000. Under her will, each child should inherit roughly $285,000. In March of 2026, Margaret's Parkinson's symptoms worsen. Emily takes her to the bank to add Emily as a joint account holder so Emily can pay Margaret's bills. The $340,000 is retitled as a joint account with rights of survivorship in the names of Margaret Patterson and Emily Patterson. Margaret dies in October of 2027. Emily, as the executor, begins the probate process. She reads the will. Everything splits 3 ways. But when the attorney asks about the bank accounts, Emily provides the statements. The attorney goes quiet. Then he says the words that will fracture this family forever. Emily, this account passes to you by operation of law. It is not part of the probate estate. It does not go through the will. Your brothers have no legal claim to this money. You now own $340,000 outright. Emily is stunned. But Mom wanted everything split equally. That is what the will says. The attorney nods. The will controls probate assets. Joint accounts with rights of survivorship are non-probate assets. The title controls, not the will. Your mother's intent does not matter. The account registration overrides it. Michael and David are sitting in the attorney's office, and the room goes ice cold. Here is the disclaimer the compliance attorneys want me to read you. I am not your lawyer. I am not your financial advisor. I am not your CPA. This is educational content, not personal legal advice. Every state has different probate laws, banking regulations, and rules governing joint accounts. If you want advice specific to your situation, hire a board-certified elder law attorney or estate planning attorney who understands your state's non-probate transfer statutes and Medicaid estate recovery rules. What I'm giving you today is a tactical breakdown of how joint accounts actually function under the law and what alternatives exist to achieve the same practical goals without the inheritance consequences. Treat this as a survival guide, not a legal opinion. Now let me walk you through the 3 layers of the joint account trap, because this is not just one problem. This is 3 interlocking disasters, and each one makes the others worse. Layer 1. The right of survivorship override. When you open a joint account with rights of survivorship, you are not just giving someone access to the money. You are transferring a present ownership interest in 100% of the funds. Under the common law doctrine of joint tenancy with rights of survivorship, each joint owner has an undivided interest in the entire account. That sounds like legal gibberish, so let me translate. The moment Margaret added Emily to that $340,000 account, Emily became a legal co-owner of the entire balance. Not an agent, not a representative, an owner. And under the survivorship provision, which is the default for joint accounts in almost every state, when Margaret dies, her ownership interest evaporates. It does not pass through her will. It does not go to her estate. It vanishes. And Emily's ownership interest automatically expands to 100% by operation of law. This is governed by state non-probate transfer statutes. In Illinois, it is codified under 755 ILCS 5/6-1, the Illinois Probate Act provision on joint tenancy. The statute is explicit. Property held in joint tenancy with rights of survivorship passes to the surviving joint tenant and is not subject to disposition by will. Read that again. Not subject to disposition by will. Margaret's will said, I give all my property to my 3 children equally. But the $340,000 was not her property at the moment of death. It was Emily's property. The will never touched it. Now here's where it gets worse. In most states, there is a legal presumption that joint accounts are true joint tenancies, unless clear and convincing evidence shows otherwise. Illinois follows this rule. The burden of proof is on the party, in this case, Michael and David, to show that Margaret did not intend to make a gift of the account to Emily. And that is nearly impossible to prove. Margaret is dead. She cannot testify. The signature card at the bank shows she voluntarily added Emily. The account agreement includes survivorship language. There is no written statement from Margaret saying, I only added Emily for convenience. Michael and David would have to file a lawsuit, hire an attorney, pay $15,000 to $30,000 in legal fees, and prove in court that their dead mother did not intend the legal consequence of the document she signed. They will lose. And even if they win, they have just spent 3 years in litigation destroying their relationship with their sister. This is not a glitch. This is exactly how the law is designed. Joint tenancy has existed in common law for 800 years. The survivorship feature is the entire point. It is a probate avoidance tool, but it only works if you actually intended to give the money to the surviving joint tenant. Most seniors do not. They just wanted help paying the bills. I need you to do something for me right now. In the comments, tell me this. Are you a joint owner on your parents' bank account, or is your parent a joint owner on your account? When was it opened, and do you know whether it has rights of survivorship? I am not asking to be nosy. I am asking because 90% of the people watching this video have no idea how their accounts are legally titled, and the consequences of not knowing are catastrophic. Drop your situation in the comments. Let us figure this out together. Every comment helps the algorithm and helps the next family avoid this trap. Now let me show you Layer 2. Layer 2. The Medicaid transfer penalty disaster. Margaret did not die suddenly. Let me rewind the timeline. In early 2027, Margaret's condition worsens. She falls. She breaks her hip. After surgery, she cannot return home. She needs 24-hour skilled nursing care. Emily moves her into a nursing home. The cost is $9,500 per month. Margaret's income from Social Security and her small pension is $2,800 per month. That leaves a $6,700 monthly shortfall. Margaret starts spending down her assets. The $340,000 joint account starts draining at $6,700 per month. Within 18 months, the money will be gone. Emily meets with a Medicaid planning attorney. The attorney asks for all financial records for the last 5 years. Emily provides the bank statements. The attorney sees the transaction from March 2026 when Margaret added Emily to the account as a joint owner. The attorney's face goes pale. Emily, when your mother added you to this account, she made a disqualifying transfer under Medicaid law. That $340,000 is now considered a gift to you. When we apply for Medicaid, the state is going to impose a transfer penalty that could delay her eligibility for more than 3 years. Here is how the Medicaid trap works. When you apply for Medicaid long-term care benefits, the state conducts a look-back review of all financial transactions for the 60 months prior to application. Under 42 U.S.C. 1396P, the Medicaid statute, any transfer of assets for less than fair market value during the look-back period creates a period of ineligibility. The formula is simple. Total amount transferred divided by the average monthly cost of nursing home care in your state equals the number of months you are ineligible for Medicaid. In Illinois in 2027, the average monthly cost is approximately $8,500. If the state determines that Margaret made a $340,000 gift to Emily when she was added to the account, the penalty period is 40 months. 40 months during which Margaret is ineligible for Medicaid and must pay privately for care she can no longer afford us. But wait, Emily says, I did not take any money. The account is still there. My mom still has access. The Medicaid caseworker does not care. Under state agency policy, adding someone to a joint account creates a rebuttable presumption of a gift equal to 50% to 100% of the account value depending on the state. In Illinois, the Department of Healthcare and Family Services presumes a gift of 50% unless you can prove otherwise. Even at 50%, that is a $170,000 gift. That is a 20-month penalty period. Margaret will burn through the remaining funds paying privately, and by the time she qualifies for Medicaid, there will be nothing left for her children to inherit. And here is the truly cruel part. If Emily had been added as an authorized signer or agent under a durable power of attorney instead of as a joint owner, there would be no gift, no transfer, and no penalty. The account would still be 100% in Margaret's name. Emily would have the exact same practical access to pay bills, but the legal ownership would have never shifted. The only difference is a checkbox on a bank form, and that checkbox just cost this family 20 months of Medicaid eligibility and $170,000 in penalties. Layer 3, the creditor and divorce exposure trap. Let us say Margaret does not need Medicaid. Let us say she lives another 5 years in perfect health and dies peacefully in 2031. Emily, as the joint owner, inherits the full $340,000. Michael and David are furious, but they decide not to sue. The family is fractured, but the money passes. Here is what nobody saw coming. In 2029, Emily's husband loses his job. They fall behind on credit card payments. They default on a home equity line of credit. A creditor sues and obtains a $75,000 judgment against Emily. Under state law, that judgment can be executed against any non-exempt assets in Emily's name. And guess what? The $340,000 joint account is in Emily's name. It has been since 2026. A judgment creditor can levy on that account and seize funds to satisfy the debt. Margaret's life savings, the money she wanted protected for all 3 children, is now subject to Emily's personal creditors. Michael and David watch in horror as $75,000 of their mother's estate is garnished to pay Emily's credit card debt. Or consider this scenario. Emily gets divorced in 2030. The joint account with Margaret is still open. Margaret is still alive. Under many state marital property laws, Emily's interest in that account is considered a marital asset subject to division in the divorce. Emily's spouse claims a share. The divorce attorney argues that Emily has had a present ownership interest in $340,000 since 2026. Even if the court determines it was a gift from Margaret, it may still be marital property if it was commingled or if Emily exercised ownership during the marriage. Margaret never intended for Emily's ex-husband to get a dime, but the joint account structure created that exposure. Now contrast this with the alternative. If Margaret had established a durable power of attorney and added Emily as an agent or authorized signer, Emily would have had zero ownership interest. She would have access for management purposes only. The funds would be 100% protected from Emily's creditors, Emily's divorce, and Emily's financial problems, because they would not be Emily's funds. They would be Margaret's. Same access, zero risk. The only difference is the legal structure. So, what is the right way to give your child access to your accounts without creating an inheritance disaster? There are 3 legally sound alternatives, and I am going to walk you through each one. Alternative 1, durable power of attorney for finances. A durable power of attorney is a legal document in which you, the principal, appoint another person, your agent or attorney in fact, to manage your financial affairs. The agent has fiduciary authority to access your accounts, pay your bills, manage your investments, and handle your finances. But the agent has zero ownership interest. The assets remain 100% in your name. They pass according to your will or trust. Every state recognizes durable powers of attorney. Most banks will honor them if they are properly drafted and include specific language authorizing the agent to access accounts. Some banks require you to use their own power of attorney form. Get both. Have your attorney draft a statutory, durable power of attorney, and also complete the bank's form. The cost to have an attorney draft a power of attorney is typically $300 to $800. That one-time cost eliminates the joint account trap entirely. Alternative 2, authorized signer or convenience account. Many states have enacted statutes authorizing convenience accounts or authorized signer designations. Under these statutes, you can add someone to your account with access rights but no ownership rights. The authorized signer can write checks, make withdrawals, and manage the account, but has no claim to the funds during your life or at your death. In Illinois, this is governed by 205 ILCS 5/5, the Illinois Banking Act, which allows banks to offer accounts with designated agents. The key is that the signature card must clearly state that the additional signer is an agent only, not a joint owner. Not all banks offer this option, and the terminology varies. Some call it a convenience account. Some call it an authorized signer. Some call it a non-owner signatory. You have to ask specifically, and you have to make sure the account agreement states that the signer has no survivorship rights. Alternative 3, revocable living trust with successor trustee. The gold standard is a revocable living trust. You create the trust, transfer your accounts into the trust, and name yourself as the initial trustee. You retain complete control. Then you name a successor trustee, typically your child, who takes over management if you become incapacitated or when you die. The trust document specifies exactly how the assets are distributed at your death. You can split everything equally among your children, create specific bequests, protect assets from creditors, and avoid probate entirely. The cost to establish a revocable living trust is typically $1,500 to $3,500 depending on complexity. But the trust governs all your assets, not just bank accounts. It is a comprehensive estate planning solution. The inheritance passes according to the trust terms, not by operation of law. No survivorship override, no Medicaid penalties, no creditor exposure. Here are your 6 action steps. Take these seriously. This is not theory. This is the exact checklist I walk my own clients through. Step 1, pull every bank statement you have. Look at the account titling. Does it say John Smith and Mary Smith, joint tenants with rights of survivorship? If yes, you have a problem. Schedule a meeting with an estate planning attorney this week. Step 2, if you are the adult child on a parent's account as a joint owner, have a conversation with your parent today. Ask them, did you intend for me to inherit this account, or did you just want me to help pay bills? If they say they wanted it split with your siblings, you need to fix the account structure immediately. Step 3, go to your bank and ask if they offer authorized signer accounts, convenience accounts, or POD, payable on death designations. If they do, retitle the account. Remove the joint ownership. Add yourself as an authorized signer or agent only. Step 4, if your parent does not have a durable power of attorney, hire an attorney to draft one. Cost $300 to $800. This is not optional. This is the foundation of incapacity planning. Step 5, if your parent is facing a potential Medicaid need within the next 5 years, consult a certified elder law attorney immediately. Do not make any account changes without legal advice. Some changes can trigger look-back penalties. You need a Medicaid compliance strategy. Step 6, if you have already inherited money from a joint account that was supposed to be split with siblings, talk to an attorney about a disclaimer or a family settlement agreement. In some states, you can disclaim your interest and allow the funds to pass under the will. In others, you can enter a written agreement with your siblings to split the funds according to your parents' intent. Do not just keep the money and hope the problem goes away. It will destroy your family. Take a deep breath. Stop guessing with your legacy. I have built a free resource to give you absolute clarity in under 2 minutes. Take the free Inheritance Protection Assessment. In less than 2 minutes, you will get a personalized report showing exactly where your accounts, your estate drone, and your family legacy are exposed to the joint account trap, unintended disinheritance, and Medicaid penalties. The report is free. The information is specific. And the clarity will save your family years of litigation and tens of thousands of dollars in legal fees. You now have the knowledge to dismantle the joint account inheritance bomb. But I have watched this scenario play out 1,000 times. People watch the video, they nod, they say they will handle it next month, and next month becomes next year, and next year becomes the phone call from the hospital. And by then the account has already passed by survivorship, the siblings are already fighting, and the attorney is telling the family there is nothing that can be done. Knowledge without execution is just expensive regret waiting to happen. Take the action steps. Protect what your family spent a lifetime building. If you are still here, you are part of the small percentage of viewers who actually make it to the end. That tells me you are serious. That tells me you understand that good intentions do not protect your inheritance. Legal structure protects your inheritance. Here's my final question for you. Pull your parents' bank statement right now. Look at the titling line. Is it a joint account? If you do not know, you have homework. I am Jordan. I do not work for the banks. I do not work for the financial services industry. I work for families who want the truth. And I will see you in the next one.